patience with me getting started here today. It's the first time, it's week 6, and it was the first time I got called to the speaker's office. So I think I'm doing pretty good if it's already week 6. Well, it's the first time. I'm still here. All right, with that in mind, we're going to go ahead and open the informational hearing on the elimination of juvenile fines and fees. And we will start with Eileen Berquist from the ACLU of Kansas. Eileen.
Hello. Again, for the record, Eileen Berquist, ACLU of Kansas. A special thank you to Chair Owens for giving us the opportunity to speak today on the very important issue of eliminating juvenile fines and fees in the criminal justice system. A few brief notes before we get started. We have shared a bill draft with committee members that was developed by the Kansas Debt-Free Justice Coalition, but there is no bill number this session. This bill was made in collaboration with partners in state, as well as national partners who have worked on juvenile fines and fees elimination across the country. Those partners include Kansas Appleseed, Progeny, Destination Innovation, Kansas Action for Children, the Galt Center, the Juvenile Law Center, and the Institute for Justice. But more importantly, this bill was written in close collaboration with Kansas youth who have been impacted by our system of fines and fees. 2 of those youth leaders will speak before you today. An additional note before we hear our speakers, this change we are suggesting does not touch on restitution. It is eliminated to the elimination of the imposition of fines and fees on juveniles, as well as the retroactive elimination of court debt for juveniles. So thank you for your time today, and I believe we have a short video to share with you before we get to our speakers.
That is correct. Thank you. And what we'll do, we have, as you guys can see the agenda, we have quite a few people wanting to speak on this issue. We will be limiting those comments to 3 minutes, just because we have a lot of work to get done today and this week. So we'll go ahead and start out with this 3-minute video. And once that's completed, we'll welcome Tyler Williams with Progeny via Webex. So if we have that video ready to share. And by the way, while that's being pulled up, Vice Chairman Smith will be our timekeeper. So just watch him for those cue cards that say when it's time to wrap up. So, all right, go right ahead.
All right, my name is Dante Bristow, D-A-N-T-E. Well, I grew up in the system, young. If you go through courts and anything like that, they are charging you for every step of the way. Court fines, bracelet fines, it's just all those fines. Probation fines, UA fines. So the poor, which is the blacker communities, we tend to not have money. We're considered poor. So if we don't pay these fines and fees, that's the cycle. We're gonna stay in that cycle because it's just gonna rack up on us. Can't get out. We have no money to get out of it. We're gonna be in that cycle. Jail, probation fines. They will put me in jail. They will put you in jail if you don't pay these fines and fees. To get in the system because of my fines and fees, I couldn't pay these fines and fees off. Like, I remember one time I was young, I had a bracelet on, I couldn't pay for it. I ended up going to jail because we couldn't pay for this bracelet. Still to this day, and I'm 23 years old, I still to this day have a hard time passing background checks because of things I did when I was a juvenile. You were how old? 14, 13, you know, all under 16 years old. I feel like I don't have a normal life because I'm constantly having to pay fines and fees and having to worry about this problem of being incarcerated because of these fines and fees. So it's hard, especially when you got kids or you have to pay these bills. Fines and fees can really be something that hurts. It affects you about jobs because if you on fines and fees, you can't get anything expunged from your criminal history until you pay out these fines and fees. I'm on a bracelet for something I did as a juvenile. I feel like because I actually moved away, I actually lived in Toledo, Ohio. They came and got me at my job down there and flew me back on a plane. They wanted me to get a job, live a life, take care of my family, pay my taxes. I was finally doing that. I finally got out the system. I felt like I finally broke it. I wasn't on probation, nothing, just living my life with my family down there. And for things I did when I was a juvenile. You don't want to be going through the same thing 5 to 10 years later from now. That's your life. And they have you I feel like on a leash. I'm 23 years old now. I haven't been in trouble since I've been a juvenile, you know. So I ain't really just started the boxing classes, but yeah, we've been coming here around 5 or 6 o'clock. You see a bunch of youth in here. Just have somewhere to hang out, you know. They're not running the streets, somewhere that they can consider a safe zone. I just get to tell my stories and try to cancel some of the, you know, bull crap that's happening to the youth within the system. You know, like I said, no youth should be punished for their fines and fees. I was a youth that was punished, and I don't want to keep seeing youth being punished for these fines and fees.
We can go ahead and stop it there. Thank you very much. All right, we'll now welcome Tyler Williams with Progeny via Webex. Tyler?
Thank you so much, Chairman. As mentioned before, my name is Tyler Williams. I am sharing my experience from the juvenile justice system. At the age of 13, I went into the Kansas juvenile justice system. My first charge placed against me and the first fine or fee that was placed against me was for a very expensive car ride to take me from Junction City all the way up, or from Oklahoma City. That trip cost me about $850, give or take. Along with the rest of my fines and sentencing, in total, I was sentenced to pay a total of $1,064.69 to the county of Gary. While I was adjudicated, I spent a total of 5 years, 8 months in facility. There, I not only had to graduate middle school, I had to graduate high school. Finally got a job where I started making 25 cents an hour and was only able to pay off maybe $300-400 of that debt. Once I was released, I was placed on probation. From there began the urinary analysis fees every month. Also became the violent offender registration fees that I had to incur every quarterly. And it definitely did not seem like it ever ended. When it comes to the different fees, there seems to not be a very beneficial way for youth to actually work down these fines. In facilities, youth are unable to really take out a big chunk of that debt. Even when families send in money, half of that gets taken out for the debt. And yeah, my apologies, I lost track. Once I was released off of probation, I was released off of probation for doing too good. At that time, I was kicked out of my halfway house, so I became homeless and began the calls of every week demanding that I pay $80 for my restitution. At this time, became homeless, had a part-time job, and
you have 1 minute.
Thank you. I was not able to financially carry this burden that I had from when I was a child and made a mistake. So all in all, I just wanted to state that my story is just one example of the financial burdens that are placed on youth that does not seem to make sense. I was lucky enough to have a support system and was able to get onto my feet and have people who were there to help me take care of these fines and fees, because without them, I would not have been able to rehabilitate back into the system. And in my opinion, and why I feel that we need to support this bill, if we really want to help kids rehabilitate back into the system, we need to help them and not keep trapping them in different forms of crisis. These are financial crises that we're putting kids into with no feasible way to get out. We need to stop treating children as adults and treat them as children. Thank you.
All right. Thank you very much, Tyler. We'll now hear from Christina Kiersey from the Galt Center via WebEx.
Hi, thank you so much for having me. My name is Christina Kiersey. I'm the Senior Youth Defense Counsel for the Galt Center, which was formerly the National Juvenile Defender Center. Our relationship with Kansas goes back a number of years. We were invited into Kansas as part of a partnership with the Kansas Department of Corrections to perform an assessment on the youth delivery system in the state of Kansas. In partnership with the Kansas Office of Judicial Administration, we conducted visits to 11 different jurisdictions in the state of Kansas. We conducted interviews, 116 confidential interviews, and 120 court observations in various jurisdictions around the state. Our goal was to find out and do an investigation into youth delivery in the state of Kansas, and to report back to everyone who's willing to read our assessment as to what can be improved in the state of Kansas. We made recommendations on how to improve justice and fairness for youth in our assessment, and I'm happy to share that assessment with anyone in the committee who's interested in reading it, or anyone in the audience who's interested in learning more. Our number one recommendation and the first recommendation that we made for the improvement of justice and fairness for youth in Kansas was to eliminate fines and fees and to reduce the financial penalties that are given to youth that find themselves in the Kansas youth justice system. It's in keeping in line with the National Council of Juvenile and Family Court Judges and their recommendation to look at reducing and eliminating financial penalties on youth. We found that in Kansas, youth are penalized from the second that they walk into court. They're given fines of $34, $22 just for filing their cases and applying for counsel. They're charged for IIPs, which under SB 367 was designed to keep youth out of the formal court system. $400 evaluation fees, lab fees, drug and alcohol evaluation fees. And then probably the highest, thank you, is the $160 to $200 a night that youth and their families are charged for time in the detention center. One defender noted seeing a detention bill, which was close to $10,000 for the family of a youth that was detained in Kansas. With that being said, I'd like to turn my time over to Mike Fonkert from Kansas Appleseed. Thank you.
Thank you very much, Christina. We'll now hear from Mike Fonkert with Kansas Appleseed. Mike, welcome.
Thank you, Mr. Chairman and members of the committee, for taking some time to hear about this important issue. I am Mike Fonkert, campaign director with Kansas Appleseed Center for Law and Justice, which is a nonpartisan organization dedicated to working to build thriving, inclusive, and just communities in Kansas. So following up on some of this testimony, just to dive just a little bit deeper into the situation here in Kansas. For some background, a growing number of states are looking at this issue. We have seen 12 states pass statewide fine or fee elimination bills since 2015, including states like Louisiana, Texas, Colorado, New Mexico, and others. And so this is an issue that when states begin to dive in, they seem to be finding consistent patterns. And we see a lot of that same findings here in Kansas. So for the committee, the revised Kansas Juvenile Justice Code establishes that the primary goals for the code include promoting public safety and improving the ability of youth to live more productively and responsibly in the community. The elimination of fines and fees is perfectly in line with that goal, and research does show that the financial penalties we're talking about today actually increase the likelihood of recidivism. So records provided by the Kansas Office of Judicial Administration to the Debt-Free Justice Coalition show that the total court revenue for juvenile fines and fees in Kansas was under $540,000 in 2020 and has decreased steadily since 2016. So what you see is an amount of money that is not a make it or break it amount, at least from our perspective, in terms of the state budget. But as we hear from young people and the research that we've done, it can be an extremely large burden for young people and their families. While the fines and fees do not raise much revenue, they do impose significant burdens. And we just got a fairly good list of all of the different areas where fines and fees can be assessed. And so we really appreciate the committee's interest in looking at this topic and finding a way to improve the justice system for young people. I think one last important element here is that a stage analysis of the youth justice system using data from OJJDP which is the Office of Juvenile Justice and Delinquency Prevention, found that Black youth were 4.5 times more likely than white youth to be arrested and 20% more likely to be adjudicated delinquent in Kansas. As a result, I think that is another factor that we have to weigh when we look at the imposition of fines and fees is the racially disproportionate impact that they may have. And for all of these reasons, we are very, very grateful to this committee for considering eliminating the burden imposed by fines and fees for young people in Kansas. Thank you.
Thank you, Mike. Appreciate that. We'll now hear from Lindsey Smith with the Juvenile Law Center. Lindsey. Welcome to the committee. Thank you.
Thank you, Chair Owens, for holding this hearing today. My name is Lindsey Smith. I'm an attorney at the Juvenile Law Center. We are a national organization devoted to equity, dignity, rights, and opportunity for young people in the child welfare and juvenile justice systems. We've been working on this issue for a little over 8 years. We published a groundbreaking report back in 2016 called Debtor's Prison for Kids that looked at all 50 states and what they're doing about juvenile fines and fees. So I've brought this map today that's from that report. This is updated to today, to 2021, to incorporate all of those changes that Mike mentioned with states including Louisiana, Colorado, New Mexico, and Texas making reforms. These show the places in the points in the juvenile justice system where fines and fees are imposed on children and families. So as you can see, as of 2021, Kansas is one of only 3 states, that's Kansas, Arkansas, and Michigan, that impose fines and fees on families at 8 different points in the system. That makes Kansas an outlier today because of the number of points at which children and families are charged money. So I just wanted to point that out as we talk about state trends, as we talk about national trends towards reforming and removing these fines and fees. And the reason so many states are coming to this conclusion when they look deeply at the problem is that these things are bad for families, they're bad for young people, they're bad for public safety, and they don't make sense as fiscal policy. Balancing the budget on the backs of children and families is not a sustainable revenue source, and it does more harm than good. There are studies showing that young people who owed fines and fees had higher recidivism rates than children who did not. So we are creating a counterproductive system for public safety by imposing these things on children. And the juvenile justice system has so many other ways to hold young people accountable, so many programs, so many developmentally appropriate interventions, that to use something that just does not make sense for children and families is something that states are moving away from. And then finally, I just want to point out that in your packets, there is a proposed draft fiscal analysis of what this bill would cost. And as Mike mentioned from Appleseed a minute ago, that is based on data we've received from the Office of Judicial Administration. We've been working with them for over 6 months to get that data. And what we found is that cost, that revenue that is coming in from this stuff is about $540,000. So again, not a huge amount. And the harm that comes out of it can be really staggering, because what happens is you have children and families struggling to pay, and then having to decide between, do we pay court debt, do we buy school uniforms, do we buy groceries, or you have children turning 18 and having either no credit or bad credit from this debt, having a hard time finding housing and jobs and all those things that are those milestones of young adulthood. Thank you very much for your time. And I'm prepared to stand for questions if it's helpful.
Thank you very much, Lindsey. We'll now hear from Mark Dupree, District Attorney, Wyandotte County, via Webex. Mark. Do we have Mark online?
Chairman, can you hear me now?
I can hear you now. Go right ahead, sir.
Thank you so much, and please forgive the slight delay there. I'm trying to get this whole thing down. Mark Dupree, Wyandotte County District Attorney, and to the chairman and the committee, I appreciate you all allowing me to speak. I am the district attorney here in Wyandotte County, and before becoming a prosecutor, I was a criminal defense lawyer for over a decade. So My experience is not just on the prosecution side, but it's also on the defense side. And on both of this side of justice, I would say I've had the opportunity of dealing with our young people, our juveniles. And I'm very happy to have the understanding and the knowledge that our criminal justice system, where it concerns juveniles, we are still focused on rehabilitation. And so concerning rehabilitation, which in my opinion really focuses in on public safety, it's imperative that we get rid of fines and fees concerning our juveniles. I'm not going to regurgitate all of the numbers and all of the data there. I'm going to tell you the facts, and the facts are this. Individuals who cannot pay their fines and fees, what prosecutors all across this state and country, what we do is we keep them on probation. We keep them on paper, for lack of better terms. And you know what that costs? That costs money. That costs money. That costs my prosecutors money. That costs core services money to follow them around, to encourage them to pay money that we know that they don't have and that their moms and dads or foster parents don't have. And so we're simply not allowing them to move forward. And the numbers and the data is clear that when they don't pay money and when they're chasing around finding funds, then they go and look for ways to make money. And if the focus is indeed what I've stated, which is to rehabilitate them, we have to give them the ability to move past the mistakes of their past. I'll also state that concerning fiscal
1 minute, sir.
Thank you. Concerning fiscal responsibility, the numbers show that here in Wyandotte County in 2019, I believe, maybe 2020, we found all the money that we could, gathering the fines and fees from our juvenile courts and all of those offenders, and we gathered a great big whopping $14,000. Here's the reality. We oftentimes spend more money chasing after these young people's money that they don't have than the actual money that they have. When we're talking about our young people, we're talking about the future of our community, and we're talking about the public safety of our community. I think it's a drop in the bucket for us to allow those funds to go aside, let them move on with their lives, be better citizens in our community, and not waste the money that we're spending to chase after them or the money that we have to spend to keep them on paper that doesn't help resolve their future. Thank you for your time.
Absolutely. Thank you, Mr. District Attorney. We'll now hear from, I believe, Kristin Powell is going to step in for Nakia Watkins with via Webex. Is that correct? Go right ahead. We do have her. Do we have Kristin with us?
Yes, can you guys hear me?
Yep, go right ahead.
Okay, yes, you were right. I'll be filling in today for Nakia Watkins, and I'm going to read what I submitted for my written testimony. So my name is Kristin Powell, and I'm a youth leader with Progeny, which is a youth-adult partnership focused on reimagining the juvenile justice system and reinvestment in community-based alternatives. I'm speaking to support to stop charging youth and families with fines and fees that come in contact with the juvenile justice system in the state of Kansas. This practice creates heavy burdens for youth and can push a young person deeper into the juvenile justice system. A majority of young people who are involved with the juvenile justice system come from poor and low-income families, and adding an extra financial obligation to their budget can cause extreme amounts of harm and stress and tension between the family. Fees start adding up the moment that a young person comes in contact with the juvenile justice system, and most youth are unaware of how much their experience with the court will cost them until they're signing the plea deal or accepting the probation agreement, and then they get the laundry list of fines. And a couple of examples would be a booking fee, court docket fees, and attorney fees. The court tells youth that if they can't afford an attorney, that one will be appointed to them, but most youth do not know that they'll still be paying for the attorney once they reach the end of the court process. It is not uncommon for system-impacted youth to spend a good amount of time in jail or in placements, and it makes it nearly impossible for them to be able to obtain jobs or employment to be able to start paying towards the fines and fees that they get from the court. I would also like to remind everyone that we're talking about school-age children who are typically in school Monday through Friday from 9 a.m. to 4 p.m. And that makes it really hard for them to be able to get employment. When these fees go unpaid, they eventually start to go to collections agencies where they sit and the interest begins to build. And when a youth is finally able to, okay, when they are finally able to gain employment, sorry, I lost my spot. Oh yeah, so it gets garnished from their paychecks. And I would just say I know all of this from my own personal experiences with the juvenile justice system. By the time I got off of juvenile probation, I had a collections account with almost $5,000 worth of debt. And I was entering into a 2-year diversion agreement where I had to pay $2,000 before I completed that diversion agreement. And that doesn't include the $20 that I had to pay every couple of days for the random UAs that I had the 2 years that I was on diversion, and the $1,300 that I was charged just for a copy of the transcript of one of my juvenile court hearings. I would just also like to say that youth are already paying for their mistakes when they're serving sentences in jail and prison and their time on probation and parole and community service. And once the youth is released from state's custody, they continue to pay with restitution and these fines and fees. And it's just seemingly like a never-ending punishment where their criminal record continues.
I'm sorry,
to
I have to
them.
stop you there. I gave you a little more time for interrupting you.
Okay.
Thank you very much, Kristin. Let's go ahead and hear from Jamie Cavanaugh now with the Institute of Justice. Jamie, are you available? Thank you.
Good afternoon, Chairman Owens and members of the committee. My name is Jamie Cavanaugh, and I'm an attorney at the Institute for Justice. Since 1991, the Institute for Justice has been fighting both in courts and in state houses to protect personal freedoms and individual liberties. IJ is especially interested in protecting private property interests. As part of this work, Institute for Justice challenges government misuse of fines and fees. For example, in 2019, Institute for Justice won the landmark case Timms versus State of Indiana. There, the court ruled that, and this is the U.S. Supreme Court, there the court ruled that the Eighth Amendment's prohibition on excessive fines was incorporated against the state. In other cases, Institute for Justice has won challenges to the overuse of municipal citations. IJ also works to end the perverse incentives created when government raises revenue through fines and fees instead of taxes. I'd like to make 2 brief points today. First, that eliminating juvenile fines and fees is a true bipartisan issue. And second, this point was already made, so I won't come back to it, but states around the country are considering these bills and eliminating these fines and fees for juveniles. But I'll briefly talk about the first topic and mention some reasons why legislators from both sides of the aisle should be interested. Assessing juvenile fines and fees is a public safety issue. As we've heard, juveniles should be focusing on education instead of working to pay back court debt. You know, if kids come out at 15, 16, we don't want them trying to find a job. We would like them to finish their education. And in the instance where a juvenile's family pays the debt, it may have to choose between paying the debt or paying the rent. And in that case, the family relationships sometimes destabilize. And that's in an instance where arguably you would want the most stable family relationship for that juvenile. So I think all my other points were made. So thank you very much for hearing this testimony. I'd ask you to consider eliminating juvenile fines and fees.
Thank you very much, Jamie. Finally, we will hear from Sean Jurgensen, Special Counsel to Chief Justice Marla Lukert. Welcome to the committee, Sean.
Thank you, Chairman Owens. I'm going to speak at you a little faster than I normally do to stay under the deadline. I'm Sean Jurgensen with the Judicial Branch, and as you're considering this issue, there are two administrative areas that we would like you to consider moving forward, fiscally and operationally. In my testimony, I provide 3 grids for you that spell out collection of juvenile fines, fees, and costs from 2 of the past 3 fiscal years. Not those costs that have been assessed, only those that have been collected. Because when we talk about costs, fees, fines, some are assessed to reimburse counties or municipalities for fees that they've fronted, things like attorney fees, alcohol, drug assessment, law library fees, whereas other fines, fees, and costs figure into the funding scheme of the judicial branch overall, things like filing fees, surcharge, driver's license reinstatement fees, things of that ilk. And so if you have the grids in front of you, the topmost grid, again, this is only on those fees that are collected, not assessed. The topmost grid will show you for FY19, the last pre-pandemic year, and FY21, the most recent year, all in what was collected. And so that amount would include restitution. The second grid, the middle grid, would show you what those figures are without restitution. And it sounds like that's the grid that the proponents of this concept are looking to do based upon Ms. Berquist's testimony earlier. And our figures in our testimony largely mirror the figures that the proponents of this concept are giving you. And then finally, the third most grid is the actual impact to the judicial branch fiscally, which is less than that because you've removed all of those other fines, fees, or costs that are being funneled into those other entities, not directly to the judicial branch part of its funding scheme. So I draw your attention to those. But the other portion of impact that we could see is an operational impact. And this is the impact that actually could pose more significant requirements on the judicial branch. The proponents are asking for retroactive application of the concept, which could impact the court system significantly because there are outstanding obligations already that have been assessed in juvenile offender cases, which would require, presently, OJA, the Office of Judicial Administration, contracts with debt collection vendors to go out and collect these obligations on behalf of the state of Kansas. And so any retroactive effect could impact those existing agreements or those cases that have already been referred to the debt collection agent. And a retroactive elimination could involve court time in determining how much of that outstanding balance may be collected. And so there's an impact that we want to draw your attention to. And finally, because we're in the process of moving case management systems, absolving a lot of this obligation could be a manual entry process, which could require a substantial amount of time for judges and court clerks to do. That's even if you can do it without separate journal entries. There are journal entries, Chair Owens, I appreciate I'm out of time, sir.
You're good.
There are journal entries out there that already exist, and within the practice of law, how you go about handling that, I can't answer that for you on how that could shake out. And then one last thing, I know that a lot of these costs and fees, they involve mental health, substance abuse treatment, counseling, mediation, that many of these obligations could fall to other governmental entities to pick up along the way if they're no longer being assessed. So other things to consider as the committee chews on it. But thank you for your time. I was trying to go lickety-split. So
Real quick before you leave, Sean, and thank you very much for your testimony. Question, if I recall, there's a bill in appropriations that would drastically change the way that the judiciary is funded. Could you address that and maybe how this would play into that?
Sure. Yeah, and which is a driving reason I wanted to include that third grid of what the ultimate impact to the branch could be. Presently in appropriations, there is a bill 2541 that would shift the way the judicial branch is funded. Currently, about 20% of our core functions are funded with fines, fees, costs, stuff like this. The bill that's in appropriation would shift the deposit of those monies from the accounts that directly fund the branch to SGF. And so that's all the bill would do, is it just shift the ultimate deposit of those funds to SGF. In return, the judicial branch would ask for 100% of our core operations to be funded by state general fund. And so when as I stand here, Chairman, that third grid would show what we would anticipate the fiscal impact to the state general fund to be next year should 2541 pass.
Very good. Thank you. Committee, I believe we have Representative Carmichael has a question.
Thank you, Mr. Chairman. My question is for Mr. Jorgensen. He's still nearby.
He is waiting just
Good
for your
afternoon.
question.
Good afternoon, Counselor. I was concerned a little bit about the testimony you gave regarding existing contracts that the judicial branch may have with collection agencies, lawyers, whatever. Can you give me a rough idea as to how many contracts we're talking about?
No, I don't know the number of debt collection agents that OJ is contracted with. I just know that they're out there. And that's something that would necessarily have to be looked at, but I couldn't tell you.
I'm sorry.
No, you're fine.
No, please go ahead.
I couldn't tell you ultimately how long that could take to ferret out, because it may involve a legal question. But nevertheless, operationally would impact those contracts that have already been executed between OJA and any debt collection vendor.
Mr. Chairman, with your permission, those contracts with OJA, are they originated out of Topeka, or does each judicial district go negotiate their own contracts with collection agencies?
Both. My understanding is that that can be done centrally through OJA, or at times chief judges have executed it on behalf of the district.
Do any of these contracts contain penalty clauses, clawback clauses, etc., in the event it becomes against the law to collect these debts, such as a bill like this with retroactive application presumably would say that it would be against the law to collect on those debts? So did OJA sign contracts with penalty provisions, or is it just that the contract in essence comes to an end because it's now contrary to law?
I don't know. I honestly don't know.
Well, without those answers, I'm not going to find that to be much of an impediment to passing this type of legislation. So I hope you could look into that. Thank you, Mr. Chair.
Thank you, Representative Carmichael. Representative Howerton.
Thank you, Mr. Chair. I just have a quick question, and you may not know the answer. When these juveniles have these fines that follow them into adulthood, does that create an offset on their tax refunds and all that good stuff? Does the state do that?
I don't know.
Okay.
I don't know.
I'd like to know.
Fair question.
You can answer that?
We have somebody in the, yeah, you certainly can.
Thank you.
Go right ahead. Just give us your name.
Lindsey Smith, Juvenile Law Center. We've, with the help of OJA, we've requested this information on collections from 12 different counties across the state. We found some that contain tax set-off provisions, some contain wage garnishment provisions or tax lien provisions. Others add fees of between 25 to 33% to the balance as soon as it's transferred over. So there's a variety of collection mechanisms that are being used based on the contracts we've received. Thank you.
Thank you. Committee, additional questions? All right, seeing none, we'll thank everybody for your time today. Thank all the conferees for sharing their insights with us. We'll now move into the hearing on House Bill 2634, and we'll ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2634 would require a waiver of extradition proceedings as a condition of bond. The bill amends KSA 222802, that's the statute about release and the conditions of release prior to trial. The bill would add a new subsection C, which would provide that in addition to any other conditions of release, the magistrate would order the person to execute a waiver of extradition. Number one, it would state that the person consents to extradition in Kansas and waives all procedures related to that extradition if the person is arrested in another state while on bond. And two, the person would have to acknowledge that the person shall not be released prior to trial in any other state pending extradition to Kansas. And I can take any questions.
Any questions for Natalie, committee? All right, seeing none. Thank you, Natalie. We'll go ahead and move into proponent testimony and welcome Greg Smith, Special Deputy Sheriff, Government Affairs, Johnson County Sheriff. Welcome, Greg.
Good afternoon, Mr. Chairman. Thank you for hearing me today. This is a bill that the Johnson County Sheriff's Office requested. Our FAU, Fugitive Apprehension Unit, asked me if we could bring this up. It's to address a problem that we have. 48 states belong to the Uniform Criminal Extradition Act, kind of like the Interstate Compact with driver's licenses and that, except for extradition. One of those states that is not a member is the state just to the east of us, Missouri. In 2021, the Johnson County District Courts filed a total of 246 fugitive cases from out-of-state fugitives that refused to waive extradition, and 193 of those cases were Missouri people that had committed a felony in Kansas and then just stepped across the line back into Missouri. I can tell you as a former Kansas City, Missouri police officer that if I made a traffic stop and somebody came back with a Kansas warrant, unless the bond amount was over $5,000, we just told them, you have warrants in Kansas, and sent them on their way. The problem we have is people leave the state and then we can't get them back because they'll fight extradition. I've got the entire process on how that extradition process works. There's a graph or a chart that I attached to my testimony that kind of takes you through that step. I've got the link in here to the actual manual, all 97 pages of it. If you're bored some night and you need to go to sleep, click on that link and you'll be out in just a few minutes. But it does walk you through that process on how everything works. The problem we have is that without some guarantee of extradition of a person coming back, a person that goes to another state, referred to as the asylum state, will be charged for a fugitive charge in that state when they become aware of our warrant. So they may have been, say, picked up for a misdemeanor charge in their home state, and then they say, oh, but you have this felony warrant in Kansas, and they'll have a hearing in front of the judge in the asylum state, and that judge can set a bond on the fugitive charge. This is not the norm, but just to give you an example of what's happened to us, we had a person that charged with committing rape in the state of Kansas, skipped out to Hawaii, couldn't get him back from Hawaii, came back to the 48 states, was in, I think it was North Carolina, picked up for a crime there. They saw our felony warrant, taken in front of a judge to have a bond hearing for the fugitive charge, and the underlying charge is rape, but in that state, it was just a fugitive charge. $2,500 bond, they paid the bond, and we still don't know where they are. They're out running around again. So the hope is that by having them pre-sign a waiver of extradition, we can, one, cut down on the whole extradition process and we can get people back into state. Certainly should save us some time, money, and resources in trying to do that, and I'd be happy to stand for questions.
Thank you. Representative Smith.
Thank you, Mr. Chair. And for those who aren't familiar with the bonding process, there are a number of criteria that you have to sign and agree to before you're allowed to bond. I mean, the whole idea of bonding is saying, I promise to appear, right? Can you give us examples on what some of that criteria may be that would go along with this if we passed it?
Well, thank you for the question. Actually kind of jogs part of what this was. In our current statute, judges in Kansas can lay any other condition and that's reasonable as a condition of bond. In talking with some of our judges in our judicial circuit, they would much rather have it written down in statute that they can do this than take their own initiative. I guess sometimes making case law isn't a whole lot of fun if you're a judge. So that's another reason that we're going this avenue so that it's actually explicitly stated in statute.
Very good. Committee, Representative Heiberger.
Thanks for being here, Mr. Smith. To your knowledge, is there anything in current statute that prohibits a judge from requiring execution of the waiver as a condition of bond?
I don't know of anything that limits a judge from doing that.
Representative Wheeler.
Thank you, Mr. Chair. Just this waiver of extradition executed before a judge in Kansas, is it binding upon a judge in North Carolina?
If it follows the same guidelines through the Interstate Compact for probation and parole, if you look at, I've actually got one of theirs with me and I've got extra copies I can give to the committee. But this is an offender's application for Interstate Compact transfer, and that last paragraph down there talks about that it is binding regardless of what state that a person is in.
Is that document one that one signs while in custody in North Carolina? or is that one that is signed before?
Signed here. It's signed in the demanding state, not the asylum state.
Thank you, sir.
Thank you. Representative Resman.
Thank you, Mr. Chairman. So if they sign the waiver, would they immediately be placed in custody then?
If they sign a waiver, what?
Would they immediately be placed in custody?
I'm not sure.
Well, my concern is that they're charged with a crime, they don't have the ability to post a bond, but so they would be immediately placed in custody, and then they'd...
Oh, yes. I mean, the idea there, now, I mean, practically, there's theoretically how it's supposed to work, and there's the practical application. I'm sure a judge in an asylum state could still say, I'm going to give you a bond on your fugitive charge. And there's not much we can do about it. But having this process in place, there are other states that do it. We actually borrowed this language from Colorado. So we know it works. We just like to get it in place here.
Thank you. Representative Carmichael.
Thank you, Mr. Chairman. Deputy Smith, I'm having a little trouble getting my head wrapped around what this does. I commit a crime in Kansas and I flee across the state line to Missouri. I'm apprehended over at Missouri. There's a warrant out for me in Kansas. Presumably, I'm arrested and held in Missouri pending extradition to Kansas. Is that generally, am I right on that so far?
Correct.
If we pass this law that says in order to bond out that I have to waive extradition, that doesn't have any impact on me, though, if I'm over in jail in Missouri, because in Missouri, I'm subject to Missouri law. But the compact may influence that. Can you help me try to get a handle on how it is we're going to pass this law in Kansas and it's going to do anything to get back a person who allegedly committed a crime in Kansas who's now in Missouri or South Carolina or Alaska, for that matter? Can you help me with that?
Well, the way that it's practically worked in other states that have done this is that the other states are much more willing to hold that person since they know that they'll be extradited back and that there won't be any kind of extradition hearings or demands on their court in order to get that person back to the demanding state.
And Mr. Chairman, with your permission, just one other question. Sure. Let's assume that Hertz falsely reports me as having stolen a car by failing to return it. The reason I use Hertz is apparently there's been thousands of those types of cases wrongfully filed. If a place in South Carolina reports that I stole a car and I really didn't, and I'm back here in Kansas and now I get arrested on a South Carolina warrant, would this law, if enacted, mean that in order to bond out here in Kansas, even though I've never been to South Carolina, that I have to waive my right to challenge extradition to South Carolina? Otherwise, I sit in jail here in Kansas waiting for an extradition hearing to prove that I've never been to South Carolina in my life except for once, and that's when we nominated Barack Obama to become president.
No, it's only for a Kansas charge, Representative. It's not for an out-of-state charge.
Okay, but we don't have any power over what bond, if any, South Carolina would set. If I was apprehended in South Carolina and was extradition to Kansas, that's outside our territorial jurisdiction, and they make their own rules about bond and conditions of bond. I'm just not following how this is going to work. Can you help me?
It's simply a document that's signed where they have waived the extradition proceedings to where they'll be brought back to Kansas. It's an inducement to these other states to help bring those people back to Kansas, to help us be able to get those people back to Kansas. We still have to do the transporting. It's our deputies that have to do it. This is just a manner of trying to make the process go a little bit smoother.
Finally, Mr. Chairman, to try to wrap this up, but I don't understand how it is the state of Kansas thinks it can impose conditions upon a bond. that's set by a judge in South Carolina. They've got their own rules about who gets held and whether or not you get out awaiting an extradition hearing. I don't understand how this would ever work.
Mr. Representative,
smiles on the
I
part of
never
my
said,
colleagues, so maybe I'm all wet, but help me out, please.
it's only for a Kansas charge. It would not be for a charge from any other state.
But Kansas law doesn't apply in South Carolina, and that's where I'm being held, awaiting extradition to Kansas.
Let's see if we can. Yeah, absolutely. Let's see if we can help ask Representative Buchheiberger to clarify all this for us.
Thank you, Mr. Chair. So would a compact state be required to honor this waiver and immediately extradite the offender?
Technically, a compact state's supposed to honor it anyway, but they're supposed to honor the extradition process, but that's not always how it works.
Okay, but what would compel a non-compact state to honor this?
Pardon me?
What would compel a non-compact state to honor this?
Simply that it's not going to tie up their courts, it's not going to tie up their resources, their manpower, their time, because we're going to get the person back to our state to answer for the charge.
So it seems to me like the section, C2, the offender has to acknowledge that such person shall not be released prior to trial in any other state pending extradition to Kansas. And that's not a binding statement. I mean, I don't see how that, and that's not an enforceable statement. It's just an acknowledgement of something that may or may not happen.
Well, as I said earlier, Representative, it's not a perfect world. I'm not saying it's going to solve every problem, but it'll certainly assist.
Representative Smith.
Thank you, Mr. Chair. I'm going to take a stab at this and give it an example that I think might work. But if a person is alleged to have committed a crime in Kansas, and as a result of the investigation, the individual is arrested for that crime in Kansas, and there's a bond set for that arrest, part of the bonding process, only if the crime was committed in Kansas and arrested in Kansas, part of the bonding process would be that you sign this saying, if I go to another state and there's a warrant for my arrest for this crime, I can be picked up in that state and held for extradition. I'm agreeing to that. And this is part of the process that would happen even if you hadn't signed that. We would have to ask that you sign a waiver of extradition while you're in Missouri or whatever state it is in order for us to come get you. Otherwise, there has to be an extradition hearing. Is that correct?
That's correct.
And that is the only circumstance that this would apply to if I sign this as a condition of my bond.
Correct. And this would only be for felony charges.
Very good. Thank you.
Thank you. Additional questions? All right, not seeing any. Thank you, sir. I will also submit to your, for your perusal, written only proponent testimony. Proponent testimony from Jeff Easter, Sedgwick County Sheriff, on behalf of the Kansas Sheriff's Association. Steve Kearney, Executive Director of Kansas County and District Attorneys Association. There is also written only opponent testimony from Max Iverson, Kansas Association of Criminal Defense Lawyers. Is there anybody else in the audience that wishes to speak to House Bill 2634?
Association. My name is Shane Rolfe. I'm the Vice President of the Kansas Bail Agents Association. I'm actually here for the next bill, but since this does relate to bail, we do support the concept that someone would not be allowed a do-over, and they've been arrested once, they've posted bond. You know, we don't want to have a situation where someone runs off to another state and then challenges their underlying charge. There's already mechanisms in law for them to challenge the charge when they're here, rather than abuse the interstate compact system or the extradition system to leave the state and fight coming back. So we would support this concept.
All right, could you get something in writing with your information and submit that so we can distribute that to the committee?
Yes, sir.
Thank you. Very good. Anybody else? All right, seeing none, we'll go ahead and close the hearing on House Bill 2634. And we'll open the hearing on House Bill 2674 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. House Bill 2674 would require a forfeiture of an appearance bond to be set aside in certain circumstances. The bill amends KSA 282807. That's the statute that provides for a forfeiture of bail and also an appearance bond. Current law in subsection A there provides that if a defendant fails to appear, the court shall declare a forfeiture of that bail. This bill would add that the court would also be required to issue a warrant for the defendant's arrest in that circumstance. And then further down, current law provides that when a bond has been forfeited and a surety can prove that a defendant is incarcerated somewhere in the United States prior to judgment of default, then the court would be required to set aside that forfeiture of the bond. This bill would add that the forfeiture shall be set aside if, one, the warrant that's now required to be issued under subsection A is not issued within 14 days of the forfeiture. Two, the surety made a request to the sheriff's office that the sheriff enter the warrant into the National Crime Information Center's index, and the warrant was not entered within the 14 days of receipt of that request. Or three, the defendant has been arrested outside of Kansas and the prosecuting attorney has declined to proceed with extradition in that case. And I can take any questions.
Any questions, committee? All right, seeing none. I do want to announce in full disclosure, many of you know that this is an industry in which I operate. As the chairman, I don't vote on this bill. And so still willing to hear it and have those conversations, but just wanted to be fully open and fully disclose that. So with that in mind, we will welcome Shane Rolfe back to the podium, Vice President of the Kansas Bail Agents Association. Shane.
Thank you, Mr. Chairman. Just curiosity, how much time do I have on this? I know we're getting up towards the half-hour point.
Good.
Okay.
All
right.
Got plenty of time. Thank you.
Okay. I am the Vice President of the Kansas Bail Agents Association and Legislative Chair of that. So I'm the one that gets sent up to deal with all these things. Our members have brought up these issues as issues of concern. As Natalie noted, one of the changes that this would make would be to require that in conjunction with declaring a forfeiture upon a failure to appear, the court is required to actually issue a warrant for that failure to appear. Now, most of the time, anybody that's had any experience in this, that's normally what happens anyway. You know, the person misses court declares a bond forfeiture and orders a bench warrant. That's normally what happens. There are some instances where that's not occurring, though. So we would like to have this put in that would be a requirement. Surprisingly, this requirement does not seem to be found in the Code of Criminal Procedure. I spent a lot of time digging through this going, well, I know it should be in there someplace. And it's in traffic, and it's in civil, and it's in, what's the other one? Oh, and municipal procedure. They all say, when you miss court, we'll issue a warrant for you. It doesn't say that in criminal procedure, and I really don't understand why. In addition to that requirement that a warrant would be issued subsequent to declaration of bond forfeiture, it creates some additional defenses to a judgment on bond relating to that. Specifically, if the warrant is not issued within 14 days of declaration of forfeiture, or if the prosecutor declines to extradite the defendant, bring them back from out of state, or if upon formal request by us, if we, after that warrant is issued, if we contact the sheriff's office and say, hey, we know this person's in another state, can you put this in NCIC so either we can go get them or we can try and proceed with extradition to bring them back. If that doesn't happen, those are all defenses to forfeiture where the forfeiture would be required to be set aside by the court. It does note in here in paragraph number 4, the change. It looks like a change. It's not actually a change. If the defendant is incarcerated elsewhere in the country, the court would be required to set aside the forfeiture, and the surety could be tasked with the cost of bringing that person back. That's been moved around, and it looks like it's new language, but it is just moving around where it's at in the statute, so that's not a change to the statute. Issuing a warrant following a failure to appear, well, as I noted, it seems nonsensical that the court would not issue a warrant when someone fails to appear. There are a handful of jurisdictions that are, if nothing else, slow walking the issuance of the warrant. Specifically, they're just doing this when the bond has been posted by a surety. They're not doing it when the bond's been posted in cash, and they're not doing it when the bond's been posted as a signature bond. They're just doing this when a bonding company has posted the bond. And essentially what they're doing is they're waiting until the 60-day grace period that's built into the statute to enforce a forfeiture has passed. In other words, 60 days has passed, you've got to pay off the bond forfeiture, then we'll issue a warrant. The argument for this appears to be, and this is a small minority of jurisdictions that are doing this, but there are a handful. The argument for this appears to be that since it's our job, the bondsman, to get this person back into custody, the state is obligated to do absolutely nothing to further the goal of getting that person back into custody. Seems somewhat petulant, but it really, the behavior demonstrates a desire more to collect the bond forfeiture than it does to get an escaped or a fugitive person back into custody. Now, we've argued this in various jurisdictions that this could potentially impact officer safety. And this is just one example that if the officer, most bench warrants, or not most, many bench warrants, even people that we've posted bond for, are resolved by coming in contact with law enforcement. Perhaps before we got a hold of them, perhaps, because we were, looking for them, whatever. Somehow, law enforcement came into contact with that person, they ran him, found they had a warrant, took him into custody. And sometimes these are just routine traffic stops. The officer pulls somebody over, hey, you got a warrant. However, when the officer pulls that person over, they know, the person they're pulling over, they know they've got a warrant. The officer doesn't because that warrant hasn't been issued. The person who's being pulled over, you never know what their reaction is going to be. Is their reaction going to be negative? Does the officer go in thinking that this is just some random person they've pulled over? Or does the officer run the tag and go, oh wait, this person has a warrant, I need to get some backup, I need to approach this in a little bit different method, for this sort of thing. So that's just one example why we think it is also important to have warrants issued right away, when somebody's missed court, because the person who's missed court knows they've missed court, and they're going to react as if they have a warrant, whether they do or not. And we don't want to put ourselves or the officer in a situation where they don't know that when they walk up on the car. The NCIC and the need for a warrant, touch on that. In addition to the basic notion that society should want fugitive defendants back into custody as soon as possible, and that all possible efforts are being made to get that back. That includes the bonding company, that includes law enforcement. Having an active warrant is oftentimes a requirement for us to bring someone back or get someone into custody who has left the state. There are 4 states that have completely outlawed commercial bail bonds, and along with that have outlawed the practice of private fugitive apprehension. So I can't send somebody into that state to actively pick that person up. I can send someone in one of those states to locate that person, contact local law enforcement, and go, hey, Bob here, Bob's got a warrant out of Kansas, can you come pick him up? I know I can't do it in your state, but he's got an extraditable warrant from your state. Now, these states are Illinois, Kentucky, Wisconsin, and Oregon. So really the most we would deal with would be the Wisconsin and Illinois and Kentucky issues. And I've had situations in all 3 of those states where we've had to locate someone and get local law enforcement to take that person back into custody because we can't physically do it ourselves without violating local law. Now, in addition to these 4 states, there are at least 17 other states that require us to turn the defendant over to local law enforcement for extradition. Texas being the one most close to us. If we go into Texas, we have to, 1, retain someone who's authorized in Texas to do that. We have to take that person into custody, and we have to turn them over to Texas authorities for extradition purposes. We can't remove them from the state. Now, and there's a number of other states that also require just simply notifying, law enforcement. And if you notify law enforcement that you're here, and actually Kansas has a notification statute that we're required to notify law enforcement before we can try to pick someone up. Some of those states, not Kansas, but some of those states have a requirement, basically if there's no warrant in the system, you can't go look for that person. Now, I think that's a violation of the contractual relationship we have with the defendant, but it is what the state law says, and we don't want to be in a position where we're violating state law. Now, as I noted, Texas is one of those states that has this kind of peculiar or becoming more common requirement that we can pick the person up, but we have to turn them over to local agent or local authorities in that. Now, the language that we've drawn up here for the requirement to enter into NCIC, that was pulled directly from the Oklahoma statutes on bond forfeitures. And that was placed into Oklahoma law as a direct result of the changes in Texas law requiring this particular procedure for getting someone out of Texas. So Oklahoma, sharing the Red River border, I guess, with Texas, made these changes because of that, and I think you're going to see more of that coming down the pike from other states, you know, that, well, we don't want people, just strange people from out of state coming in, so we want to have some control over these pickups. Now, the other argument is refusal to extradite if the state decides that they don't want to extradite. Now, if the previous bill passes, even if a person has signed a waiver, the prosecutor or the sheriff's office still has to be willing to bring that person back. But, you know, just because they've signed a waiver doesn't automatically mean they magically, you know, get transported back to Kansas. The local agency still has to go get that person. I've attached to my written testimony an article from the Kansas City Star that was written last April. And it beats up on Wyandotte County, but Wyandotte County is not singular in this. And starts off with, Wyandotte County has a secret policy allowing low-level felony suspects to escape prosecution if they can just get a couple states away. Now that sounds sensational, and it was supposed to be because it was an editorial. But what it functionally means is Wyandotte County, unless you are charged with a person felony, so a violent crime, unless you're charged with a violent crime, if you're not in an adjoining state or if you're more than 200 miles away, they won't go get you. You can have a warrant out for the rest of your life. As long as you stay more than 200 miles away, they won't go get you, and as long as it's not a violent crime. This sort of harkens back to the old get out of town. You always heard these stories of, you know, back in the 60s, the deputies would pick up the guy walking down the street and drop him off across the county line, and the other side just get out of town. It's generally not the accepted way we do law enforcement anymore. But the result of this sort of behavior, and I'll quote the Star on this, is the result is prosecutors, courts, and deputies are sending a message that criminals can skate if they just skate far enough. Said, you better believe the criminal element knows about it, even if the law-abiding public does not. Now, I've kind of beat up on Wyandotte County here because there's a newspaper article for me to draw from to beat up on that, but they're not the only ones that do this. Several small counties make this calculation that it's awfully expensive to bring this person back from out of state. And so they've chosen this from a financial-based approach. We're not going to go get this person because they're a long ways away and it'll cost us money. While we don't think that's a good approach to law enforcement, we think you know, whether there's cost involved or not, you should be bringing back fugitives. It doesn't really apply when there's a bail bond involved because this statute itself already provides that the bonding company can be assessed the cost of bringing that defendant back from another incarceration, whether it be out of state or not, in lieu of paying the bond forfeiture. So it's not going to cost these counties any money if they pick somebody up who has a bond, you know, that's on bond, because the bonding company can be assessed the cost of bringing that person back. Unfortunately, though, many of these counties that do this, while I'm not going to bring this person back from Texas or wherever it happens to be, I'm still going to pursue this motion for judgment on bond. You still have to pay even though you know where this person is and you can't legally go get them in that state, but you're going to pay this bond forfeiture. And that was actually the topic that was discussed in that newspaper article that I've attached. Obviously, we don't think that that's particularly fair. Motions for judgment on bond, which is what this statute deals with, despite being referred to as a motion, is actually a civil lawsuit that is allowed for sake of convenience to be filed as a motion within the criminal case. But despite that, at its core, a motion for judgment on bond is still a civil action for breach of contract. And like every other contract, the parties to that contract, particularly the aggrieved party, in this case that would be the state of Kansas, have an obligation to mitigate their potential damages. Cornell Law School has a deal. Mitigation of Damages doctrine prevents an injured party from recovering damage that could have been avoided through reasonable efforts. Reasonable efforts is important. Classic example of this is if a pipe bursts in your house, a reasonable effort would be to shut the water off so it doesn't keep leaking in your house and doesn't cause more damage. Requiring the state to issue a warrant in a timely fashion and to actually seek extradition of defendants from out of state is not unreasonable. And in fact, it is what most jurisdictions already do. As you guys know, a lot of times you get to deal with the outlier situations. We are simply asking that the state be required to, in a sense, shut off the water in order to pursue a motion for judgment on bond to try and collect money from the bonding company. And we think that the passage of this bill will do that, and we would urge you to support passage of this bill. And I'd be happy to answer any questions.
Thank you, Shane. Representative Smith.
Thank you, Mr. Chair. And I'm going to ask Natalie, if you don't mind, on this. And in the bill, under the statute, in fact, let's look at the bill. On line 12, it begins, an appearance bond may only be forfeited by the court upon a failure to appear. Later in that same paragraph on line 14, the end of it, an appearance bond is revoked by the execution of a warrant for a defendant's arrest for a violation of a bond condition. Does that not indicate that the forfeiture can only occur when a warrant is issued, or the warrant has to be issued upon revocation?
Would you like me to address that?
Let's hear from Natalie first, if she has something, and then we'll go to you as well.
Mr. Chairman, so subsection B, and obviously Shane's a lot more well-versed in this, so I'm sure he can add to this, but subsection B is talking about the revocation of that bond if you violate a bond condition, not necessarily the forfeiture of like when that bond is forfeited.
When the defendant fails to appear, the bond is forfeited. Shane, you want to take a stab at it?
What we're referring to here, Representative Smith, is if the court does choose to issue a warrant for a failure to comply. It's not a failure to appear, but if the person has failed to comply with some other condition and the court issues a warrant for that failure to comply. Oftentimes they don't. Oftentimes they'll just have a hearing and make a decision at that time in open court, but sometimes they will issue a warrant. This language is here to acknowledge that once the person is arrested on that warrant, the bond is functionally revoked and they're back into custody on that. So if they need to get back out, they need to post another bond rather than, well, now we're going to have two bonds operating in the same case at the same time.
Can I feed that back to him, see if I got it?
Sure.
So outside of a failure to appear, it would be some other non-compliance that the warrant or the bond would be revoked.
Correct, like positive UA or failure to check in with court services or something along those lines.
I got it. Thank you.
Excellent. Representative Carmichael.
Thank you, Mr. Chairman. Mr. Rolfs, if I understand this correctly, defendant's supposed to appear today. Defendant does not appear. Judge says bond forfeiture, arrest warrant, or maybe doesn't say bond forfeiture, just issues the arrest warrant. Clerk's office is extremely busy. Everybody's got COVID. It's a holiday. They don't get that warrant, quote unquote, issued until 15 days from now, and they issue it on the 16th day. Does that mean the commercial bondsman or bondswoman is off the hook?
The technical language of the statute, yes, that would be the case. Now, quite frankly, I don't think that normally happens that long. And the incident or the situation we're trying to address with this is where the court is intentionally holding the warrant and not issuing that until the deadline dates have been passed on the motion for judgment on bond.
I understand that that may be the intent, but the way this would actually work, I think, is just as I've described. If the clerk's office doesn't get the warrant out by the 14th day, they get it out on the 15th day, the commercial bondsperson is off the bond, no longer responsible to find, retrieve, return, or do anything else with the defendant because they've been released from the bond. Is that right?
The way the language is written now, that is the case. If the representative is concerned with that, there is another place we could insert that language, which would be in, I believe, paragraph 4, what used to be paragraph 4, and just say 60 days following the declaration of forfeiture and issuance of warrant, which would give us the full 60 days following the issuance of the warrant, rather than simply say, well, if we don't have it issued within 14 days, you're off the hook. What we're trying to avoid, again, is not have a situation where the court is not trying to do anything to bring this person back until the bonding company's already had to pay the bond forfeiture.
Let me turn, with the chair's permission, to a second circumstance. And by the way, don't count on me to try to fix this bill, because this isn't an area of my particular legal expertise. If I have any anywhere, it's certainly not in bail bonds. how much time does the sheriff, upon issuance of the warrant, have under this bill to enter the warrant into NCIC before the bail bondsperson is let off the hook? The bail bond company would have to make an affirmative request of the sheriff's office to enter that in for this to kick into place, and they would have 14 days following that notification or that affirmative request to put that in place. So once again, if the bondsperson requests the sheriff to enter the warrant in NCIC and the sheriff is busy chasing murderers, rapists, and other folks, and they don't get around to entering it into NCIC until the 15th day, does that mean the bondsperson is now off the bond and no longer responsible to locate or return the defendant to appear for the charges against the defendant? It does mean the court would be required to set aside the forfeiture upon the request to do so, yes. Is there any recommendation you might have how we could modify that to 60 days? Or I guess it's actually a very different circumstance, isn't it? Yeah, that's sort of a different circumstance, Representative. That's basically making sure that we can go out of state or make efforts to get that person back into custody if they've left the state. Well, I have a lot more questions, Mr. Chair, but I know time is valuable here, so I'll keep them to myself for now. Thank you, Mr. Rolfs. Thank you.
Representative Heiberger.
Could you address briefly the difference between revocation and forfeiture of the bond?
Forfeiture of the bond is when the defendant has failed to appear and the court has declared a forfeiture of the bond, which then kicks in and we're asking the warrant be issued at this point in time, but the forfeiture then kicks in the clock of the bonding company has to get that person back within 60 days following a motion for judgment on bond. A revocation of the bond would simply be the person has violated some condition of the bond, the court is going to consider revoking the bond that they're on, more than likely raising that bond to a higher amount or adding some additional conditions to that bond to help garner compliance, but the person has not missed court. Once they've missed court, and this happens in my area, in Johnson County a lot, they might issue a warrant for failure to comply, and then if the person does not appear at their next scheduled court appearance, they'll quash that warrant and then issue a new warrant for failure to appear and order a bond forfeiture at that time.
But if the bond is revoked, the bonding company doesn't lose its money.
I'm sorry, if the bond is revoked? No, the bonding company would only be able to have a judgment taken against them in the event of forfeiture.
All right, committee, additional questions? All right, seeing none. Thank you very much, Shane.
Mr. Chairman?
I don't have any other proponent, neutral, or opponent. Do we have anybody else in the audience that would like to speak on this bill? All right, seeing none, we'll go ahead and close the hearing on House Bill 2674. And the last thing on the agenda for the day is final action on House Bill 2607. If we could ask Natalie to give us an overview on that.
Thank you, Mr. Chairman. House Bill 2607 was the bill clarifying the time limitation for habeas corpus claims.
Very good. This is the bill that we heard on Thursday, if you guys will recall. So committee, in regards to House Bill 2607, were there any amendments?
Mr. Chairman, I have an amendment.
I thought that you might. Thank you, Representative. Natalie, could we get that distributed, please? And while that's being distributed, if you would like to share with us what it is about.
I will do that, and then I'll have Natalie correct me. No, it addresses the concerns raised by Mr. Perkins about the possible confusion of the time limit based on different calculations in the federal and state system. It extends the period for filing for the situations that the bill addresses to 1 year beyond the effective date of the bill. It also addresses the request of Attorney General's office by changing the effective date of the bill to publication in the Register, so it actually shortens the extension by a few months.
All right. Committee questions for the reviser or for Representative Heiberger? Would you like to move that motion?
Yeah, I'll just note it's my understanding that both of the conferees were in agreement on the amendment, and so I would move my amendment.
Very good. We have a second. Representative Smith seconds. Committee, any further discussion on this amendment? Seeing none, you may close.
I close and move my amendment.
Thank you very much. Committee, all in favor of the Heiberger amendment, say aye.
Aye.
All opposed, nay. All right, the ayes have it. That amendment is passed. Are there any additional amendments? Seeing none, do I have any additional discussion on this bill? Anybody care to make a motion? Representative Smith.
Thank you, Mr. Chair. I move that HB 2607 be passed favorably out of committee.
Very good. Do I have a second? Got it. Thank you. Do I have a second?
Second.
We'll give that to Representative Keither as our second on that one. Thank you. Any further discussion, committee? All right. Seeing none, you may close.
I close.
Very good. Committee, all in favor of passing House Bill 2607 out favorably, say aye.
Aye.
It's amended.
Any opposed by the same sign? Or by any opposed, say nay, excuse me. Very good. The ayes have it. We'll get that one processed out. Committee, thank you very much for your time and work today.
Chairman, I'd like my vote recorded, please.
Can you confirm that you are in the building, Representative Carmichael?
As a matter of fact, right here. Here you go. Yep. There's the door. You can look out there. You can see maybe out the window the State Judicial Center.
That's like your video's not on, so we're just going to take you at your word, Representative Carmichael. We have Representative Carmichael and Representative Heiberger in the affirmative. Very good. Thank you very much again. For now, be on the lookout. We'll work these two bills we heard today tomorrow. Here's some more bills and keep the train moving. So thank you all for your work, and we'll be adjourned.